Good morning and a warm welcome to the 24th meeting of the Education Skills Committee. Can I please remind everyone to turn off their mobile phones for the duration of the meeting. Agenda item 1 is a decision on whether to take item 6 in private. Does anyone object? Well, thank you to committee members for that. And next, agenda item 2 was a declaration of interest. I understand Mr Adam has some technical difficulties. We'll return to that item after our next agenda, if members are content to do so. Thank you. Agenda item 3 is a consideration of Children's Hearings Scotland Act 2011, Children's Advocacy Services, Regulations 2020 draft, SM5 22706. It's a draft subordinate legislation that is subject to an affirmative procedure. It has 2 agenda items. Firstly, the committee will have an opportunity to ask the Minister questions, and after that we will turn to agenda item 4, where the formal debate will take place on the motion. And can I welcome to committee this morning Marie Todd, Minister for Children and Young People, and Tom McNamara, Head of Youth Justice and Children's Hearings at the Scottish Government. And could I invite the Minister to make an opening statement?
Thank you, Convener, for the opportunity to introduce the draft instrument. The Children's Hearings Scotland Act 2011, Children's Advocacy Services Regulations 2020 make provision concerning children's advocacy services under Section 122 of the Children's Hearings Scotland Act 2011. Section 122(2) includes a requirement on the chairing member of a children's hearing to inform the child of the availability of children's advocacy services, unless they consider that it wouldn't be appropriate to do so. Section 122(7) defines this as services of support and representation provided for the purposes of assisting a child in relation to the child's involvement in a children's hearing. So this is specifically about advocacy for children referred to hearings. Section 122(4) contains a regulation-making power allowing Scottish ministers to make regulations for or in connection with the provision of children's advocacy services. The objective of these draft regulations is to ensure the right support is available for children and young people, and that the arrangements for providing children's advocacy are effective. The draft regulations set out the qualifications to be held by persons providing children's advocacy services and the training they are required to undertake. They also make provision regarding the payment of expenses, fees and allowances by the Scottish ministers. The primary role of children's advocacy is to support children and young people to express their own needs and views and to make sure their rights are respected. This will support decision makers to make informed decisions on issues which influence children's lives, where those issues are considered within children's hearings. If passed, the regulations will apply where the Scottish ministers have entered into arrangements with a service provider under Section 122(5) of the Act for the provision of children's advocacy services. Persons are only qualified to act as advocacy workers in children's hearings under this scheme when they have completed training and qualifications in accordance with the regulations. Under Regulation 4(2), the Scottish ministers must provide or make arrangements for this training and qualification to both current and potential child advocacy workers. Regulation 5 specifies the matters on which training must be provided. This includes legislation relevant to children's hearings, possible outcomes of hearings, rights of children and young people, and the roles and function of the child advocacy worker and other key children's hearings actors. Section 122(5) enables Scottish ministers to enter into agreements, contractual or otherwise, with any person other than a local authority, Children's Hearing Scotland, or Scottish Children's Reporter Administration for children's advocacy services. Following careful evaluation of expressions of interest last year, grant funding was offered to 10 third sector providers. In combination, they will offer Scotland-wide coverage to children. The use of third sector providers ensures independence of new services from the named public bodies. This allows grant funding to be made to providers on one-off payments for expenses, fees and allowances to child advocacy workers where appropriate. Provisions under Regulation 7 mean that the Scottish ministers can consent to the continuation of pre-existing advocacy relationships at the point of commencement of these regulations. This will offer an element of choice to children and young people as to who may provide the advocacy for their children's hearings. We'll consider all evidence emerging from these new services, exploring how best to support children and young people coming to hearings. Working collaboratively with stakeholders, our efforts have ensured that the services are ready. They're already operating informally now to support children and young people. I'm happy to take questions.
Thank you very much, Minister. I'm looking to my colleagues. Does anyone have any questions for the Minister? Yes, can I bring in, I see Jamie Green, Beatrice Wishart and Kenneth Gibson. I'll go to Jamie first, please.
Thank you, Convener. Good morning, Minister. Thank you for that introduction. I've just got a few questions reading through the documents we have. The first one is around consultation and engagement around this. It says that no formal consultation was carried out, but engagement with relevant stakeholders. Can I ask why the decision was made not to go to any formal consultation for the affirmative procedure, and who was consulted, how were they consulted, and what the feedback was?
Ms Todd.
So we have an expert reference group which consists of stakeholders who helped us to develop this legislation and who have connections with a whole variety of different organisations within the sector, and we felt that that covered appropriately what was required. We think that actually this, one of the criticisms of the situation that we're in is how long it has taken to develop this advocacy service, and I think that it has been robustly scrutinised during development all the way through. There have been a number of pilots and opportunities for people to question. I think what that has done, while it has taken time, what it has done is enabled us to hit the ground running with a system that we know that will work and with which we know the vast majority of people are comfortable with it.
Thank you, that's very reassuring. My other question was, it states around the purpose of this instrument is that these new regulations will set out the qualifications to be held by people providing children's advocacy services and the training that they require to undertake. I guess the obvious question is, will the introduction of this instrument prohibit anyone who currently provides advocacy because they are either not qualified or will have not received the necessary training? What will they have to do to be qualified? And what support will the government give those individuals or indeed organisations who are currently able to provide advocacy, but may not be because of the prescriptive list of qualifications and training that they now must undertake as a consequence of this?
So there is a bespoke course to go along with this regulations, making advocacy real in modernised hearings. And most of it, I think that actually the bulk of people who are already operating will be able to achieve those qualifications very easily. And we've, over the course of the summer, taken about the same numbers. I think there's about 60 to 90 people offering advocacy already in the system. And I think we've had over 70 completed the course over the course of the summer. So I think I don't think the qualifications will be a barrier at all to people who are operating in the system. And in fact, the evidence is that we've vastly increased, almost doubled the number of people who are able to work in the system over the course of the summer already.
Thank you. That's equally reassuring.
Thank you. Can I bring in Ms Wishart, who I believe is the last member of the committee who wants to ask a question? Beatrice.
Yeah, thank you, Convener. Actually, my question was around consultation, and the Minister has answered it in response to Jamie Green's question, so thank you.
Thank you very much. That concludes questions from members at this point in time, so we now move to agenda item 4, which is the formal debate on motion S5M 22706, and I can ask the Minister to move the motion.
Moved.
Thank you, Minister. Can I invite contributions from members? And no one's indicating they want to come in. Apologies, my phone is ringing on my. I don't know if that came through to people. And can I now put the question to the committee that motion S5M 22706 be agreed? Are we all agreed? I'm not seeing any indications otherwise, so we'll take that as agreed. And can I thank the Minister and her official for attendance at the committee this morning. Before we pause just for a few minutes to allow witnesses to change, can we go back to agenda item 2, and can I welcome George Adam as a returning member to the committee, and ask Mr Adam, has he any interest to declare at this time?
Thank you, Convener. I'm sorry for being a wee bit late. Not a very good start, but I've got absolutely nothing to declare with regards to the committee, and if anyone wants to check anything, can check my published register of interest on the parliamentary website.
Thank you very much, Mr Adam. We are now moving to agenda item 5, which is the Redress for Survivors Historical Child Abuse in Care Scotland Bill Evidence Session. And we're hearing from organisations who have been working directly with survivors. And can I welcome to committee this morning David Whelan and Harry Aitken, former boys and girls abused in Quarriers homes, Flora Henderson from Future Pathways, Helen Holland and Simon Collins from In Care Survivors Service Scotland, INCAS. And I would like to invite the witnesses to briefly tell us a little bit about their organisations. So I'll go to Mr Whelan first.
Thank you for inviting us. We're a campaign group. We set up in 2005 officially, but we were campaigning previous to that for a couple of years. We've clearly been involved in these issues since 2002. Our members initially were elderly. We don't keep a member registration, but we have an informal group which we continue to consult with across the board. There's different from residents from different generations in Quarriers. Consult with migrant children in Canada and Australia in terms of when we try to put a policy together. What we've tried to do over the years is represent the best interests of the former residents of Quarriers, but our ethos is to make sure that anything that's set up is for all the survivors. We're also engaged in, for us, the end of this should result in reconciliation with all the parties, but in particular for us, it's about reconciling the issues with Quarriers. So on that basis, we've engaged with Quarriers senior management over a number of years, and we are in discussions with them, including in terms of the redress bill and the number of issues that they may have or we may have, and we're trying to find some common ground.
Thank you, Mr Whelan. I wonder if Mr Aitken wants to add anything to that?
I don't need to. David's covered it quite well.
Thank you very much. Can I ask Flora Henderson on behalf of Future Pathways?
Thank you very much for having me. I'm Flora Henderson, and Future Pathways is Scotland's in-care survivor support fund. We were set up by the Scottish Government in 2016, and we're overseen by an alliance leadership team that includes alliance partners, Scottish Government and survivor representatives. And our alliance partners include Health in Mind, the Mental Health Foundation, Penumbra, and the Glasgow Health and Social Care Partnership in terms of the Glasgow Psychological Trauma Service. We are a needs-led service, and we exist to help people who've experienced childhood abuse or neglect in care to live healthier, more fulfilled and independent lives. And the response to this has been significant. More than 1,600 people are now registered with Future Pathways, and we have directly worked with 1,200 people. We work with people of all ages, from the ages of 18 to 89. Most people live in Scotland, but smaller numbers of people live across the UK and overseas. We were developed to be a person-centred service, appreciating that the impact of abuse can be wide-ranging and lifelong, and we've found that individual support needs vary considerably. And we've had plenty of experience supporting people through the Scottish Child Abuse Inquiry and other difficult processes such as civil actions and in anticipation of redress, which is now before you. Thank you.
Thank you very much. Can I invite Helen Holland on behalf of INCAS?
Good morning, convener. I'm not sure if this is...
Yes, we can hear you fine, Helen.
Oh,
thank you.
Sorry. Good morning, convener. Can I just say, first and foremost, that INCAS is actually in-care abuse survivors. It's not in-care survivors of Scotland. Sorry, just to highlight that. You're okay. It's absolutely fine. INCAS started in the year 1998. Initially formally formed in the year 2000. We have been involved from the very beginning, just basically offering support for survivors initially, and then having to go on the campaign trail because trying to raise the issue of the in-care abuse within the Scottish Parliament. We have very much been involved right at the very beginning for the initial petition that went into Parliament, went into Petitions Committee and then went into the main chamber in Parliament for the debate. So throughout this whole process, we're an unfunded organisation. We have hundreds of survivors registered with us. We try to offer concise and accurate factual information for survivors because for me that's the most important thing. And I've engaged with the government on many occasions at every process of this. We were also involved with the initial consultation for this whole bill. We asked at that point Scottish Government to make it clearer because there was initial misunderstanding among survivors. Some people were struggling with the questions. So the Scottish Government said that they were prepared to come out and speak to groups of survivors, which they offered to both groups and agencies who were representing survivors. INCAS took up that call and we held 3 meetings in Glasgow and we held 2 meetings in Aberdeen, and I did one in Perth and one in Dundee. So we tried to go across the country to make sure that survivors understood the consultation and to encourage as many survivors as possible to engage with the consultation. And I'm pleased to be here this morning and able to answer questions as they arise.
Thank you very much, and apologies, my script was wrong. So, but we'll make sure we get that right in the future. Simon, is there anything you would like to add to that?
Other than just to say that since 2014, I've been the legal advisor for INCAS, both in terms of lobbying and preparing for the child. Legal advisor for INCAS, both in terms of lobbying and preparing for the child abuse inquiry and representing them at the inquiry, but also in terms of redress. So for the last 6 years, I've had the pleasure of working alongside Helen and the committee of INCAS and trying to help them and observing the work that Helen and indeed David and Harry and the other survivors do so selflessly to try and promote the appropriate redress and recognition for the survivors of abuse.
Thank you all very much. Just to mention that we did have an informal session with survivors this morning that brought to the fore some interesting lines that I'm sure the committee will be picking up today. One of the themes was around non-financial redress and apologies. And in the spirit of David's comments about reconciliation, I'm going to move to my first colleague on this area, and that's Miss Wishart.
Thank you, convener, and good morning, panel. I'd like to ask about the public apology process, and I'd like your views on the value of a public apology to survivors, and your views on what form you think that might take.
Okay, I'm going to the representatives for former boys and girls abuse in Quarriers Homes. If you both want to come in, that's fine, but if you could give an indication, David or Harry, who would like to take that point first? Shall I start, Claire? Yes, absolutely. Thank you, Mr. Whelan. Yeah. Okay, in terms of an apology, clearly it's up to the individual survivor. It has to be person-centred. I think clearly we have an apology law which FBGA helped to get put into legislation, which enables the organisations now without fear of liability to make an apology. But we also believe that the organisations have a role to play in the non-financial redress process. So in terms of, and I'll speak about Quarriers, in terms of Quarriers, they have an aftercare service, which they've had, and my understanding from Chief Executive Ron Cully is that they've put quite some substantial financial resource into that to help address some of the historical abuse issues, to help survivors with records, to support relatives, locate families, etc. So I think the terms of non-financial redress are clearly very important. But I do go back to what I initially said. It really is for the individual survivor of what they do. But I think a very powerful, a very meaningful apology coming from the organisation directly to that individual, for me, is one of the most important things. Thank you very much. And I'm looking to, Harry, did you want to come in at all on that point?
Good morning, Claire. I didn't say that at the beginning, but nice to see your smiling face. Just to endorse what David has said, recently there was a visitor from Australia, Sue Brown, I think Sue Brown her name was, and she came to Scotland particularly to tell the people of Scotland how they managed the apology in Australia. Now that was a seminar that she ran, and that was packed full to the gunnels. The two things that I came away with was it had to be meaningful, it had to be delivered at the right level of the organisation or at the government, and also it had to be validated. This idea of the apology being made to a survivor without validation, which actually authenticates it and makes sure that it has been done at the right level. So the levels are suggested would be at the chief executive or the chairman level of the organisation. And with regard to the government, we expect it would be at the First Minister level. The First Minister already knows many of us and has worked with us, so she would be, I'm sure she'd be quite happy to do that. With regard to the survivors themselves, it has so much meaning to them. It, in some cases, is sufficient that if there were no redress scheme, that the apology would be sufficient, and that we know from the people that we deal with, that means a great deal to the survivor. And
Thank
also,
you.
could I add?
Yes, absolutely.
To the family.
Yeah.
Thank you.
Thank you very much. If I could go to Ms. Henderson next.
Future Pathways won't feel able to represent survivors directly on this matter simply because we're aware that survivors would have a range of views about what is appropriate for them. And we would exist to be able to help irrespective of each person's views on redress.
Thank you. Ms. Holland, and then I'll go to Mr. Collins.
Thank you. In relation to an apology, absolutely, it's very, very much what an individual what would make sense to them. There are some survivors who, for them, an apology, it's far too little, far too late. The damage has already been done, and sadly, a lot of survivors carry resentment and anger about what's happened to them. They still haven't been able to process it. They're still dealing with the trauma of it. So for them, their attitude is they don't want an apology. I'm just being totally upfront about the various views that have been given in relation to our own members. There are other members who, for them, an apology is the most sacred thing that could come out of this, because it acknowledges the abuse that took place, and it's also an apology not only on behalf of the government, but also in some respect from the care, more so from the care providers themselves. And it can't just be a tokenistic apology. If it's a tokenistic apology, then that in itself is going to create more damage. So it very much depends on the individual themselves, what they're looking for an apology. So to answer that on behalf of survivors would be wrong. If you were asking me to answer it on behalf of what it means to me, then I would be able to give you a personal view. As a survivor myself, for me, an apology needs to come from the government in relation to why legislation wasn't followed, why were all this abuse allowed to take place in these institutions, why did nobody follow it through, why were social workers not following up with the children, why were children locked up and forgotten about, because that's what it felt like as a survivor. The doors to these institutions were locked. We weren't prisoners, but we'd absolutely no rights whatsoever. And nobody bothered to ask us what was happening in these places. And if anybody tried to tell somebody what was happening, they were accused of lying. So there's a lot there. I did receive an apology many years ago from an individual from the organisation where I was in, and I accepted that as a heartfelt apology at the time. But sadly, in relation to things that have happened since then, it's kind of tarnished it a bit. I'll be totally honest with you, and I think my initial response to that apology, I would like to try and hold on to rather than the tarnishing. But I think the apology is a really difficult one, because it's very much down to an individual. The whole redress scheme is about individuals. It's about their experience. It's about what's meaningful for them. And the only person who can really say what's meaningful for them is them as an individual survivor.
Thank you. Mr. Collins?
Thank you, Convener. It's difficult for me to add to views of those who are survivors and to speak on behalf of those who are survivors. And I endorse what Helen says. This has to be, in many ways, a very personal matter. What I would say is that in terms of what INCAS has been asking for by way of apology, it's nothing new, in that before the then First Minister's apology, such as it was in 2004, there was consultation around the terms of the petition presented by Chris Daly. And at that point, it was made clear by INCAS that what they were seeking in terms of apology was that it be sincere and heartfelt, and that it is delivered on behalf of the state and those responsible. So in terms of what an inquiry might mean to the individual survivors, I think that's very hard to gauge such a personal issue, and you've had a range of views that could be expressed in that. In terms of what it would require to be, that's been made clear by INCAS from as far back as 2003, I think it was, when that consultation was undertaken. And there is no secret made that an apology must be heartfelt, sincere, and delivered on behalf of those who are responsible. Unfortunately, I'm not sure that was the result that came out of the consultation in 2004. In fact, I know that it wasn't. But the views of INCAS have been made clear for some time.
Thank you very much. I'm going to try to cover a lot of the areas that we've been looking at, and I'm not looking for detailed answers at this point in time. This is just I'm going to ask about support for applicants, but not legal support. This is about whether the provisions for emotional support and any other kind of support that might be required, if you feel that the provisions in the bill are adequate. And I'll go again to Mr. Whelan first for that.
The short answer is I think the government has put in the right support. Whether it's the right level of support, we don't know until actually the individual what they require. But in terms of what they're covering within the bill, in terms of counselling and trauma support. We see that covered in the bill, so we're pleased to see that.
Okay. Mr. Aitken, I don't know if you want to add anything to that.
Yes, just to say, endorse that with David, and to say that the Scottish Government Redress Scheme support teams are already showing their mettle, and we know that that's going to be a thing which will continue while the scheme is up and running. The other thing, just as an indicator, is that the support teams from the Scottish Child Abuse Inquiry, they have been extremely helpful. And if the same continued quality can be taken up by the redress scheme teams, that I think would be wonderful for the survivors. That's to say that also in the matter of support, it's surprising that there are support groups being set up by survivors themselves. You have the FPGA, you have the INCAS, you also have a group called SAFE, and we just heard recently that a lady up in Aberdeen has started a group of over 20 people some of them were in foster care. And that is an initiative that has been started by survivors themselves. And most of us have contributed to that in some way.
Thank you. Ms. Henderson.
Thank you. We would echo the importance of having support made available early and with choice available for all individuals who are considering participating in the scheme. Future Pathways has learned that a lot of people can perhaps underestimate the personal impact of participating. So it's really important that the support is made available as early as possible and people can have some choice. And by choice, I mean that individual support needs may well differ, but the themes that we would draw out based on our experience of working with 1,200 people is that the supports of psychological assessment and support is important. Some 493 people have accessed that from Future Pathways out of the 1,200 participants. Counselling is also very important. Again, 518 people have accessed this, and we work with 40 professionals and organisations. And really my point in bringing this information to you is just to highlight how important it is for people to be able to choose what support is required by them, and for the support provider to do all they can to ensure that people get what support is needed. And finally, not to forget the importance of practical support, which might be about managing the practicalities of the application procedure, interpreting sometimes quite large amounts of information, and appreciating that this might need support through the whole process. And it would be remiss for me not to mention the importance of access to records in this. And that's not only about accessing information from institutions and authorities, it's about the availability of emotional support alongside, and the sincere and authentic involvement of social work or the institutions themselves, so that that information is provided in the best way possible. Too often people don't know what information is held, they don't know when they can access it, and sometimes after long periods of time they find that no information is available. And that will be absolutely crucial for people who seek to proceed through this process. And the type of support that will be required will be both for the organisations that have experience shepherding people through that process, and also to the local authorities and institutions who should be providing that information in a timely way, in a way that's easier to make sense of for people, appreciating that this is people's lives and it's hugely significant not only for redress but someone's identity and understanding of their life. Thank you.
Thank you. Ms. Holland?
Thank you. I think support has to come at two levels. That there are two different types of support. There's life support, but there's also support through the redress process, which is a different thing entirely. And I think the support through the redress process should be equivalent to the support that's available to survivors through the inquiry process. Because I can honestly say that despite the fact that that's been a difficult process for survivors, I haven't had any survivor complain about the support that they received from that support team going through that process. And that was only the process to be able to give evidence for the inquiry. So if it's an independent support mechanism that's set up to take survivors through the process of redress, that's totally different to ongoing support in their life, etc. It's a different level of support altogether, but they're both equally as important. The redress process is a process that's going to be more difficult for some than it will be for others. If we're taking the legal side out of it altogether and just talking about emotional, etc., the exact same things applied in relation to the inquiry. I can't think of anything more emotional than giving abuse to the Scottish Child Abuse Inquiry. And I know that it took, I gave evidence there myself, and I know the level of emotional impact it had on me, and I consider myself a particularly strong survivor, but there was support there every single step of that process, and I think that same level of support needs to be in place for survivors in relation to the redress scheme. The reason I say independent is because there are so many views out there, and this has been going on for far too long. I mean, for 20 years, people have been influencing survivors. There is a lot of things going on just now that we'll probably talk about as it comes up, but the reality is it needs to be that it's for the best interest of the survivor, not an organisation, not a group, not a survivor group, anything like that. It needs to be that it's in the best interest of that survivor themselves, so that they're getting the best information they can possibly get, and it's clear, and there's no pressure whatsoever pushing them in one direction or another, and they know exactly that they're getting all the support that's required to go through this process for however long it takes.
Thank you. Mr. Collins.
I don't think there's anything that I would seek to add other than to echo that I think whilst the Child Abuse Inquiry and the redress scheme are totally independent of each other, there are such similarities, not only in the people that they're dealing with and the survivors and their own needs, but also in the sort of work that they're having to look at, that there is the opportunity to learn from the experiences of the SCA, the Child Abuse Inquiry. And for what it's worth, my observation of that is that they put together a strong and effective support package. It may not be everyone's experience, but that's what I've been getting inquiry throughout. So I think that if you're looking for a model on how to provide support, that's a good example.
Thank you. I'm now going to move to the area of waivers and fair and meaningful contributions. And I have two colleagues indicated they want to come in this, Mr. Gray and Mr. Neil. So Mr.
Sorry, Claire,
David, sorry, David, I missed that. You did want to come back in. Thank you. Sorry.
Sorry, I just wanted to say to the committee, in terms of survivors have their own, and I agree with Helen, survivors have their own independent support mechanisms. We are not a support group, so we always refer survivors to the agencies or wherever. In terms of about choice, it is up to, for us, it's about the survivor being able to choose. And some survivors are accessing qualified professionals today and getting counselling and etc. So we would want that to continue if that was that survivor's choice, and for the redress scheme to endorse that. In terms of the model that the Child Abuse Inquiry are using in terms of dealing with trauma and dealing with applicants and victims, I think it's exemplary. I went through it myself. As Helen says, we may be considered strong survivors, but actually the trauma that we endured is lifelong. It's very, very difficult. And even for someone like me, all I can say is the support I had through the Child Abuse Inquiry was exemplary. And I've had feedback from other former residents of Quarriers who say the same thing. So if you can base something around a model like that, that would be really helpful.
Thank you very much, David. I'm going to ask committee members if they do want to come in on other areas, if they could indicate in the chat, that would be helpful. But in the area of waivers and fair and meaningful contributions, I'm going to go first to Ian Gray.
So thank you, Convener. The colleagues will know that the bill contains a requirement for those who access the redress scheme to sign a waiver that they will give up their right to pursue a civil claim. And the Scottish Government have argued that this is necessary in order to incentivise the contribution to the redress fund from organisations who've been responsible for care of survivors in the past. And I really just want to hear from the panel whether they believe that this is desirable or necessary or acceptable.
Go to Mr. Whelan first again.
Mr. Gray, I noticed that you raised you spoke to in one of the first panels to Joanna McMeeting. In the 2017
Sorry, we've lost Mr. Whelan at the moment.
Consultation, there's no mention of waiver. In the 2000
David, I'm sorry, I'm going to have to interrupt.
Legislation appears in the 29.
David, can I stop you there? Sorry,
so in terms
connection.
Sorry.
Can I ask broadcasting to maybe mute Mr. Whelan? Mr. Whelan, sorry, we're not able to hear your contribution very well at all at the moment. I'm going to ask our clerks to speak to broadcasting to see if we can't get you on in a better connection, and we will come back and let them do that in the background. If I could bring in Mr. Aitken to see if he's anything on the issue of the waivers and Ian's question.
First thing to say is with regard to the waiver, it seems that
I think I lost you there.
I think Mr. Aitken, if you continue, I think we'll try and sort out the connection with Mr. Whelan to see if we can't get into.
I was just about to say that from the European Court, that it's not acceptable that any government should demand that a survivor or a citizen should sign away their rights. And in fact, it should be the duty and the obligation of a government that they protect citizens' rights. So that established, we know that there are other ways of going through the redress process. For example, offsetting has already been put forward by a number of people. There's suggestions which have been put forward by David Whelan himself to the Interaction Review Group, and I think you have a copy of that. But there is one anomaly, it's probably stronger than anomaly, is the difficulty that has arisen with the pre-64 category applicants to the redress scheme. Since the Limitations Child Abuse Scotland Act in 2017 came into force, many survivors still have an unobstructed path to accessing justice. However, the application of prescription law denies the pre-64 survivors access to the civil courts. As a result of this, the proposed redress scheme does not meet their needs or their expectations. So to compensate the pre-64 survivors for this deficiency and to comply with all elements of the Scottish Human Rights Commission framework, the Scottish Government should give careful consideration to effectively rebalancing this discrepancy. And from the perspective of the number of submissions to the committee, I think it's over where there's a groundswell of overwhelming non-support for the waiver. And that is an indicator of how widely that has felt in the community. Thank you.
Thank you very much. Ms. Henderson?
Again, Future Pathways wouldn't feel able to represent survivor views directly, simply because they are varied and we are governed in partnership with the government.
Okay, thank you. Ms Holland?
To be honest with you, initially my response to the waiver was the fact that it protected the abusers more than it did the survivors. But the other reality is the fact that, you know, even if somebody was to go down the civil court route, at the end of it, once an agreement has been made that the survivor agrees that it's the right agreement for them and it's the right level for them or the right amount, whatever it is, they will then sign something at the end of that process. So even within the redress process, survivors shouldn't be asked to sign anything up front. In Northern Ireland, survivors are asked to sign a waiver before the process even starts. So at least in Scotland, what we're seeing and what we will continue to see is that no waiver should be signed until a survivor is absolutely 100% given all the information that they require to be able to make a decision as to whether or not the redress payment that they've been offered is correct for them, and they feel that they're happy with that. Only when they feel that it's the right choice for them should somebody sign a waiver. To say that it denies survivors going to the civil court route, the reality is the time bar has been lifted since 2017. If survivors had the body of evidence required to be able to go through the civil court routes, those processes would already be started. And I think it's difficult for survivors because, and I know survivors are listening to this, that's the reason why I'm trying to make this clear. The reality is that there are choices there. You know, I'm hearing people saying that survivors have been denied their rights. At this moment in time, they're not being denied their rights. There's no waiver signed until a survivor agrees that it's the right thing for them, and at that point they would have legal advice as well. But yes, I mean, I think there is an element in the waiver that protects the care providers in relation to contributions or whatever you want to call it. And I think in that sense, maybe it's possible for an amendment in relation to that, because if care providers sign a waiver and then decide further down the line where they're not going to comply anyway, then as far as I'm concerned, that waiver should be null and void, and that survivor should then have the right to pursue them elsewhere. There needs to be clear definition as to what the waiver covers.
Thank you. Mr. Collins, do you want to come in? If you could just give it a wee bit to delay broadcasting catching up with us, Mr. Collins. Sorry. Thank you. We'll find out.
I've read a lot of the contributions from the other firms of solicitors and the legal views that are expressed in the British Human Rights Centre. And I tend to say my reaction from a legal point of view, and my natural reaction is to be entirely opposed to the issue of waiver. However, I have to recognise that I represent the interests of INCAS, and you'll have heard Helen's view, which is a pragmatic view in many ways. But there's a couple of things that I think need to be borne in mind. The first thing that struck me was on reading the Vice briefing document for today's hearings. On page 2, there's a suggestion that applicants will have to choose between redress and civil actions. That suggests that this is just simply a choice of one of two means. It's not that. Applicants would choose if they were simply electing to accept a payment. But they have to go beyond that. They have to waive and give up a fundamental right to further action. So it shouldn't ever just be seen as a choice. If waiver didn't operate and there was no requirement for waiver, then you'd have a straight choice. The second point I'd ask you to bear in mind when you consider these matters is something that was raised, I think, also in the response, if I remember rightly, maybe within Digby Brown's response, where they talk about the time at which a waiver is signed. The possibility of civil action may be essentially little or none. There may not be the evidence, but times can change. And if someone who makes a decision based upon the fact that at that time they stand alone claiming that they were abused in a particular setting and has no support, having been throughout their life since they were the child abused, alone and without support, they may elect properly and appropriately on advice given to go down the route of redress. A year later, 5 years later, someone else comes forward and all of a sudden the access to the civil courts is opened. They have signed a waiver which will prevent them from going forward. It may also impact upon the other party who hasn't signed a waiver, who doesn't have the support of that previous survivor. Now, these are issues that are unknown. Within the bill as it's written, and this is something I think that needs to be borne in mind as well by the committee, within the bill as it is written, there is provision for error within the payment and determination. This is Chapter 5 of the bill, of Section 71. Section 71 envisages that there may be situations where, with the best intentions, in making a decision on redress, an error is made, a fundamental error, which results in that decision being considered to be inappropriate and having to be revisited. If Parliament is recognising that there can be error amongst professionals who are involved in this service, it must also recognise that there may be errors on the part of the survivor who makes a decision which they later regret. The difference is, where that error is made within the redress process, you can correct it under Section 71, where later on matters come to light which result in a survivor thinking, I was wrong to sign the waiver. There's no way back. But can I say to you, I'm very anxious to address other issues around waiver, such as the level of advice that is given to survivors and when that is given, such as the implications of Section 89, Subsection 3 as currently written, and the position where a contributor is in default. I'd like to address them. I don't know if they need to be addressed at this point, because actually the question that we were asked was about the waiver in general terms. So I'm happy to leave it at that just now, but I would wish to come back on those other issues in due course.
Thank you, Mr Collins. I do have questions now from 3 other members, so maybe if it's not covered, we'll come back to you at some point in this section. But I know Mr Whelan wanted to come back in. Sorry about the connection issues.
No problem. Apologies. I think I got disconnected. In terms of the waiver, our understanding is that legal advice is not being provided on whether to accept the waiver. And we think that's a crucial point, and it's a key point. And in terms of our current position is we're not in favour of the waiver. In fact, what we would support is the offsetting as being put forward by the Scottish Human Rights Commission. In terms of that, and this is about, can you make someone could go down a civil route who's had a redress process, right? And say, for example, they received 40,000 from Redress Scotland. Now, the civil process allows for out-of-court settlements, court-awarded damages, payments from criminal injuries, payments from advanced payment schemes, and other ex gratia payments could all be deducted from the civil court process. So if Redress Scotland have actually paid someone, and that person, I think you're taking away choice. I do believe you're taking away a right, and that right is choice. It shouldn't be one or the other. It should be that, listen, the Scottish Government changed the time bar law because it was wrong. You're now putting in effect into a legislation process something that's going to tell survivors, actually, you can't go down that route. Why did you change the time bar law if you don't want us to take up that as a process?
Thank you. Mr Gray, you finished your questions?
Yeah.
Okay, can I bring in Mr Neil, please?
Specifically address this issue. The whole purpose of the waiver provision is to incentivise the offending institutions, if I can put it that way, to cough up some money in terms of what they really should be doing in terms of trying to account for past errors. So do you think that if you take away the waiver provision, that then that will lead to these organisations not making any contribution? And do you think that their contribution from them should be made compulsory rather than going down the route of trying to incentivise institutions that got it so badly wrong in the past.
Okay, Mr. Whelan, do you want to go first again? I'm just going in the order I introduced you, I'm afraid.
Mr. Neal, I think it has. We cannot, ultimately, the current organisation cannot be allowed to fail on the back of the past wrongs, you know, and in terms of their financial position, that needs to be considered. In terms of the delivery of services now and in the future, that needs to be considered. One of the things that we campaigned for was the protection of children in the future. We do not want, you know, if organisations genuinely can't contribute a substantial amount to this, then there has to be a way found where we find a solution, an equitable solution. Organisations such as Quarriers have, as I said earlier, have a very good substantial aftercare service. Should that not be taken into consideration as part of redress? Quarriers, I know, have paid around £700,000 in terms of the Scottish Child Abuse Inquiry and historical abuse issues to date, because we've met with Quarriers and they've told us that. Should that not be taken into consideration? I don't think it's about. We never campaigned for all these changes for us to damage the organisation, for us to, when you say it's about holding the organisation to account, the Redress Scotland's not going to do that. The Redress Scotland is there to acknowledge a trauma that happened and a wrong that happened. And ultimately, the primary stakeholder who was responsible for all of this is the state. So the state has to take the ultimate responsibility here, because they failed in their regulatory duty, they failed in their inspection duties, and some of these issues arose because of failures of the state. Yes, we think there should be contributions.
Okay, Mr. Aitken, do you want to come in?
Yeah, just to add a couple of points. It would be right and appropriate that the demands on a former carer or a contributor is proportionate to the number of survivors that have come forward and identified themselves as having been abused. But there is one thing that's very, very important. The financial status of these care homes must not be put under serious financial distress. The effect on the capacity of that organisation must be allowed to continue so that they can service their providing services which they already give. And in the case of Quarriers, I know, or we've been told, that they have 5,000 people who they service and support in all kinds of ways. If the debts are called in, it could affect the status of an organisation, or it could put them into liquidation. But take into account that already they are giving non-financial support across the board. Their contribution, that could be added up to what they're trying to do in the community. So it's a balancing act here. If we are too stressed, too stringent on the contributors without looking into their financial status and expecting that their debts must be serviced in some way or another, it would really distress them beyond their ability to survive. Thank you.
Okay, thank you. Ms Henderson, I understand your organisation is slightly different from the other two with us today, and that you are fully funded by the Scottish Government and may not want to comment on these issues, so please feel free if I bring you in. If you don't want to comment, that's fine, but I'll give you the opportunity on this one. You want to come in?
Thank you. I have no comment.
Thank you. I'll move to Ms Holland and then Mr Collins.
Thank you. In response to Mr Neil's questions, do I think that the contributions should be compulsory? My own response to that is absolutely, because the reality is these care providers allowed this abuse to take place. The majority of the care providers still in operation are covered by insurance companies. The reality is that money that's paid out will primarily come from the insurance companies, not from the individual organisations themselves. Many of these organisations have huge assets which are hidden, and we know that. I mean, because we had a situation quite a while ago where, you know, we had a sort of situation where the care provider was saying they couldn't afford something, and when we told them what was on their offshore account, very quickly it was covered without any problem. Now, I see the waiver as not just so much in relation to contributions, but the support, the organisations are saying that without a waiver, they feel that they're open to having to pay amounts twice. But there's ways around that. There's ways where that doesn't need to happen. But the reason I'm trying to think about it from the point of view of survivors who won't have access to the civil court action and will only have access to redress because they don't have the body of evidence or proof to go to civil courts. They don't have the ability to go to civil court because they're pre-64 survivors, or emotionally they might just choose not to go to the civil courts. That's their right, that's their choice. But the most important thing is that the redress is as fair and just for any survivor who chooses to go down that route. And to me, that's the most important thing. It's about what's justice for survivors, not what's easier for care providers or anything like that. I mean, I totally get the issues, but the reality is this is about what happened to survivors. The Scottish Government, yes, the Scottish Government are responsible in the sense that we were children and we were under the care of the state. I mean, when I was in care, my dad was paying the local authority contributions for my care as a child. I mean, how disgusting is that? We're now in a situation where we're talking about contributions, and part of that contribution is protecting the care providers to some extent. I mean, and there are many other survivors who were in the same boat. There are survivors who still have all the receipts that their parents kept for the contributions they were paying for their care, not knowing that their children were being abused in these institutions, simply because they weren't allowed anywhere near their children. So there are huge connotations around this that will have an impact on survivors.
Yes, thank you. Mr Collins.
Thank you. I appreciate the comments Mr Neil makes about the need for some form of incentive so that, I think it was, as it was put, so that the providers would cough up. And the question, I think, was whether, if the waiver wasn't there as an incentive, whether they would. There's 2 points to that. I agree with Helen that these should be compulsory contributions, but what we have to an extent is an element of compromise, that by offering some sort of a carrot to the providers, they will engage. They do have an advantage of engaging anyway, because if there are survivors who are able to pursue a civil action, by resolving matters through the redress scheme, they avoid the possibility of significant legal expenses. So there is an incentive in that. However, there are many survivors, as Helen and the others have pointed out, that won't have any recourse to the courts. I would put the question the other way around, though. Where is the guarantee that with the waiver, these organisations will contribute? And of course, at some point I want to discuss the implications of Section 12, Subsection 7 of the bill. But the simple fact remains that it is entirely possible that an organisation could undertake to contribute in a fair and meaningful way, and we have to take it that will be transparent and obvious so that survivors are satisfied that the contribution is a meaningful one. They could undertake that at the time the survivor signs a waiver, and the next day they could walk away and refuse to pay. They are no longer scheme contributors, but they are still specifically protected by the waiver. That for me is illogical and is dangerous. It would be dangerous and illogical if this were merely a fanciful suggestion that care providers might, on one hand, indicate that they will contribute and then thereafter renege upon that deal or default as it's put in the bill. But it's all the more important when you realise that that is exactly what has happened in the experiences of the Irish scheme, that care providers who have undertaken to be contributors have thereafter failed to contribute. So it is to be expected, in my submission, be expected that there will be care providers who will gain the advantage of saying we are going to be the good guys here and contribute, who will gain that advantage, who will obtain a waiver whereby if they don't then contribute, what they have is the threat of the Scottish Government pursuing a debt rather than a survivor pursuing the recognition and acknowledgement and proper redress. So that's a real concern. I suppose to answer the question, I would agree that it should be compulsory. I agree with Helen on that. I think as a matter of fact, the best compromise we may have is voluntary, but that voluntary contribution has to be enforceable and has to be enforceable under the pain that if it is not enforceable, they are no longer viewed as scheme contributors. The bill as it is currently drafted would mean that even when they default as scheme contributors, they still have the benefit of a waiver as a scheme contributor, even though that does not apply to them. That is a nonsensical and dangerous position to leave us in. So, I mean, I want to address section 12, subsection 7, but that may have covered the points. I suppose that's a real concern that I have.
Okay, Mr. Phelan wants to come back in. Okay, you're still on mute, David. Sorry, we missed the start, David. There's a wee delay between broadcasting getting that you unmuted.
No
Sorry,
Claire. In terms of if you're trying to effect reconciliation and you're trying to get as many organisations, large and small, to contribute to this, yes, I agree there's not a lot of trust out there in terms of the survivor community. Yes, some groups have moved on with their care providers and have constructive relationships with their care providers, etc., such as ourselves and Warriors. I see how can you compel an organisation to give something they don't have? Now, in terms of hiding assets and all that, some of these organisations have the best financial minds, financial advisors, and are able to hide. And I think there is a weakness in the bill anyway. I don't believe the government will be able to chase something, a debt. I think it's so complicated within the financial world that it will be hidden and protected. So I think then the government's spending money chasing money that they may not be able to get. These people have had years and years of experience of where they can hide assets, how they can protect assets. So I think in terms of that, it's become rather complicated, I think, when something didn't need to be this complicated. And in terms of people signing away a waiver, a right, I still go back to my original points about that.
Mr. Neil, do you want to come back in?
I won't ask another supplementary because we're running out of time, but just to say that it seems to me, in terms of what I take out of that, is we need to separate out the two issues of the redress scheme from what contribution institutions and on what basis they should be making it, in which case the waiver is not good. I think the universal point is the waiver is not going to act as an incentive to deal with the questions should be contributing. And I think I take Simon's point, even if they agree to it, they can then renege on it the minute the waiver's signed. So I think there's a lot for the committee members to look at here. But in the interest of time and be fair to the other members who want to ask a question under this heading, I'm quite happy to move on, Convener.
Thank you, Mr. Neil. Very helpful. I've got Mr. Green and Mr. Johnson both wanting to come in. Go to Mr. Green first.
Thank you. Can I thank Mr. Neil for his generosity in that respect? I won't labour this point too much, but I think there clearly are two schools of thought. There are some who've given evidence in writing or verbally who are intrinsically against the concept of a waiver, and on the other side of the coin, those who accept the need for it and see the benefit of it in some respects, in the way that it will encourage participation from those that we want to contribute, and it's an acceptable means to do so, as we saw is the case in other schemes in other parts of the world. And I guess that finding that balance is going to be difficult. My question really, and not everyone needs to answer it, is irrespective of that, people who have contributed evidence to us feel that the waiver does strip them of their right to pursue other action. And one of the harrowing pieces of evidence that I've been reading this morning, somebody who said that this bill strips us of our right to sue. The government is asking us to sign a waiver to give up our rights to raise civil action. So whether it's technically true or not, that's what people feel like the bill is doing. How do you think we help survivors understand what the bill is trying to achieve, and how do we improve the communication of what the bill does and does not do? Because I think this issue of waiver is one of the issues that flags some of the communication problems that we're facing.
Yeah, thank you very much, Mr. Green. I'm going to suggest if you don't have anything in addition to add, please don't feel you have to come in. But if I go to Mr. Whelan first on that point.
I think we agree with Mr. Neal. Perhaps you need to separate out the waiver and the contributions as a committee. In terms of the waiver, if there has to be a legal text or if there has to be a waiver, perhaps this committee could agree that, and that should be publicised so that everybody, the survivor community, can see. Should it be on the face of the bill? I'm not sure if that is possible, but what people are concerned about is what is it they're signing away. I will say this to you. We keep hearing this is for the survivors, this is for the survivor community. Well, if it's for the survivor community, we are the primary stakeholders in all of this. Everything I see and everything I've read about the waiver, about it.
Okay. Mr. Whelan, we're getting a bit of a problem again with your connection. Just to let you know, we did manage to hear most of what you said there, and I think we've got the gist of it. Mr. Aitken, could you raise your hand if you want to come in? Right, Mr. Aitken's content with that one. Helen, you had your hand raised.
Yeah, thank you. I think one of the most important points is, and I take on board what Mr. Green was saying, one of the most important points for the survivors is that they're given factual information. The redress scheme is an alternative to civil court action. It's not instead of, it's an alternative. And that needs to be made perfectly clear to survivors. I mean, there's a lot of confusion out there, and it's because there's a lot of misinformation. There's a lot of inaccurate information being given to survivors. And that's not helpful to anybody. So whether it be survivor organisations, whether it be legal representatives, no matter who it is, you're doing the survivors a disservice by confusing them even at this early stage. The reality is redress is an alternative, and what we're all trying to achieve is that it be as best an alternative that it can be for those who choose through their own right not to go down civil court routes, for those who can't go down civil court routes, for those who may choose to take an out-of-court settlement, for those who don't want finance at all. That's their right as well. So for every survivor, the whole meaning of redress is individual to them. But to make out that it's somehow in fighting against the civil court action is wrong. It's an alternative for survivors to the civil court action. And that the whole point of the redress bill is to make that as best an alternative as possible.
I think, Helen, that sums up. Sorry, just to say that sums up perfectly the scenario. I guess maybe something for us to consider is how the government can better communicate what the redress scheme does and does not do, and what other options are available to people.
Yeah. Simon, you wanted to come in on that too?
Yes, thank you. I think from a legal point of view, it is that there is the signing away of a right. But I think that really what is being asked, and the point that remains, is what does that actually mean to a survivor? And that will depend upon circumstances, because a pre-64 survivor in signing a waiver is signing away nothing, because they have no right to access to the courts as it stands. Others, it may depend upon whether or not, if they do not sign away that waiver, they would have a prospect of success in a civil case. Now, this brings in the issue of advice. I think survivors, for it to be made clear, they have to be given clear advice on what the impact is to them as an individual of the signing of the waiver, and it will be different in every circumstance. And for that to happen, as is envisaged within Section 89, subsection 2, they have to be given advice on whether to accept an offer of payment. Much is made of 89, subsection 3, which is whether or not they will be allowed to have advice about accepting the redress as an alternative to pursuing civil action. I read that differently, and I want to raise this. I would ask the committee to seek some clarification on what is meant by Section 89, subsection 3, because it states the fees for advice will not include any fees incurred in connection with legal advice and assistance on whether to pursue litigation as an alternative to making an application for a redress payment. If you're asking for advice of a lawyer at a stage where you're saying, I haven't engaged, should I go down redress or should I look at civil action? Then I agree that it's not appropriate to pay for legal advice then, because what you're going to end up doing is funding every survivor or every individual who wishes to have advice on whether civil litigation is appropriate. If that is what that means, it's fine. I don't think that section precludes you from taking legal advice on whether to pursue litigation as an alternative to accepting an offer of redress. And survivors must have advice on whether they should accept an offer of redress, which includes what their prospects of success are in a civil litigation environment. Because without that, they're signing away a right and they don't understand what they're signing away. Section 89, subsection 3, I would ask you to take that forward and clarify that, because if it means prior to making an application and engaging in redress, I accept it. If it means at the point that is envisaged in subsection 2D, then it is entirely inappropriate to put that condition upon that. Survivors, when they sign the waiver, must know what they're signing away. And I don't know if that can be clarified in the legislation. It can certainly be clarified by the provision of appropriate advice at the time of signing.
Okay. Thank you. Mr. Green, are you finished?
Yes, that's really helpful.
Thank you. The next person to come in is Mr. Johnson. He did have an ad on the waiver, but he's also got questions around the level of redress offered. So I'll leave it to you, Daniel, where you're going. With Mr. Johnson's mic, please.
Yeah, I've just done it myself. I think if I may, convener, I think I'll ask a brief supplementary and then go on to my questions. Yeah. So the supplement, I'd just like to go back to both Mr. Collins and Mr. Whelan, because they alluded to a point, and I just want to make sure I'm interpreting something correctly. So one of the issues that strikes me at the heart of the waiver is that I think it perhaps views matters in too starkly a financial way, in that one of the key things that the waiver will do is prevent an individual from essentially getting an acknowledgement of culpability or fault, because explicitly Redress Scotland is unable to find fault. A payment is not an inference of fault. That's in the legislation. And given that we've heard already this morning just how important the apology and the acknowledgement of that wrongdoing is, both from the state and individual organisations, is the waiver problematic, not just because of it prevents access to the courts, but because it prevents the possibility of an individual having that formal attribution of culpability?
Okay, I'll again go back to Mr. Whelan first.
Yeah.
I think, Mr. Johnson, I think it is recognised that the Redress Scotland is an acknowledgement of the trauma. It is acknowledgement. It is not liability. It is not accountability. I would actually say to you that probably the accountability for a number of survivors came through the child abuse inquiry, and I know that's not concluded in terms of. And you're right. Some survivors may want to go down. I still think there should be an option of being able to go down. Once you've had all the legal advice, and I'd say you should have legal advice from the very beginning of Redress Scotland, when you, even before you sign the form to say you're a participant, that legal advice, because there will be a caveat in the form, which is an oath of affirmation. So you should be given advice from day one that you want to access the Redress Scotland scheme. And once that legal advice is completely exhausted and the survivor is happy with everything they have been told, including any options the legal advice may give them, if at that point the survivor wants to accept an award, as in other schemes, there has been a legal text that says you're accepting this award. And what we try to do in terms of what we've submitted as a discharge thing is we just wanted the committee to look at the legal the legal sort of wording of such a thing, because I think that's really important if you go down this route. I think it's really important that, you know, do you name the institution in there? Do you name a number of institutions? Do you name the Scottish Government in there? So I think it's two of our examples. One is a soft example. I would say the other one is a harder example. But there's no acceptance of liability, and we need to be clear about. We need to be honest with the survivors. We need to be honest that there's not accountability here. What we always envisaged this process would be, and I'll keep going back to it, is reconciliation. We cannot go on for years and years and years, you know, with these issues. There has to be addressed. We support the principles of the bill, and we just want to improve the bill. And I hope I've answered your question.
Thank you, Daniel. I'm very conscious of time. I'm just looking to see. I see Helen wants to come in, but I'm conscious that we've covered a lot in this topic and with other areas. So I'll let Ms Holland in, and then if you move on to your next area, that would be helpful. So, Ms Holland.
Sorry, I just wanted to. I just wanted to make a quick response in relation to what Mr Johnson had said there. People can go to the civil court action in relation to the payment side of things. But there's nothing to stop them then coming to the Redress Board of Scotland and asking for the letter of apology, the acknowledgement of that abuse has taken place. So for them, you know, that the opportunity's there to seek financial redress through the civil court action, but then also to be able to come to the inquiry and ask for the apology and ask for the acknowledgement of what took place. They don't need to sign a waiver in order to be able to do that. That should be, as far as my understanding of the redress scheme, is that would be available to them. So it would cover it from both people going through the civil court action as well as people going through the redress scheme for the Scotland Board as well.
Thank you.
So, Mr Collins wanted to come in as well very quickly. If we could try and keep the answer to me, but concise now, that would be very helpful.
Just very quickly, if there is a meaningful and fair contribution from a provider to the redress payment that's made, that will, I think, in many ways be a comfort to the survivors, and that there is a degree of acknowledgement in that. I just want to go back on one point. It's mentioned about separation of contribution and waiver. My point is perhaps the opposite. The waiver must be conditional upon contribution, and without contribution, there is no protection of the providers. Otherwise, they can just take advantage. So they should not in any way be protected if they do not provide that level of fair and meaningful contribution. Because otherwise, all that is happening is the state is picking up the bill, and the survivors are not getting acknowledgement or redress from those that harmed them.
Thank you, Mr Johnson.
Thank you. So my main question is about the levels of payment, and in particular around the individual assessment, where, given that we've got the 3 bands, there's 2 parts to my question. First of all, the only principle set out in the bill is around the extent and duration of the abuse that took place. So first of all, I would wonder if that's too narrow, whether or not things such as the consequences of the abuse, and indeed whether or not it should, the preventability, as it were, or other factors should be taken into consideration, and should they be put on the face of the bill. But more importantly, I've got huge concerns about the sensitivity of essentially tiering abuse, and the fact that survivors coming through this process will find themselves essentially categorised, and the outcomes of that might actually be quite detrimental or traumatic in and of themselves if survivors find themselves in one category or another, almost regardless of what levels of payment are attached to those 3 tiers. I was just wondering what the panel's response to those thoughts are.
Okay, go to Mr. Whelan again first. Thanks.
In terms of, we don't know how they've worked out the formulas, Mr. Johnson. We don't know how they've arrived at these formulas. In terms of what should be included, I would refer you to Dr. Susanna Lewis's written statement to the committee, and one has to ask, why have they taken impact out, or why is impact not the impact of this abuse on someone? Why is that not included? Why is and I'll read what Dr. Lewis said. The bill was proposed that impact would not be considered in terms of the level of redress payment, with the rationale that disadvantaged victims whose psychological or physical injury may outwardly seem less severe. However, I would ask that impact is considered within the context that it is evidence that the survivor was abused, whether it's evidence of post-traumatic stress disorder, behaviour consistent with neurodevelopment trauma due to neglect, or where a survivor has mental health difficulties consistent with attachment disorder. We're also concerned, if you're saying, if this really is to address what happened to the individual, and this is the other thing, should remain person-centred and individualised at all times. And you know, why is there no consideration for loss of opportunity, whether that be education, whether that be career, jobs? We know that the survivor community has had real challenges in even participating in the wider society because of what's happened to them. But I think there's a number of things missing. And in terms of each individual should be, it should be based on the facts. It should be based on the circumstances and the experience and the merits of the individual case. The way it's framed, and because we don't know how these formulas were arrived at, is that for me, it's what the government's trying to do is, and I don't want to be highly critical because I appreciate that in a number of other schemes you will have scales, and we've seen scales, but we don't understand how they've arrived at these. We don't understand how they've gone from 40 to 80, etc. So I think you need to take account of the type, the nature, the severity of the abuse, the longevity of the abuse, the period of the abuse, the loss of opportunity, and the lifelong consequences of the abuse. And I think there's a number of factors in there that are missing in terms of the structure of that currently. And I think it could be improved.
Ms. Holland?
I don't think it will come as any surprise to say that we don't agree with the levels at all, in any shape, form or manner. especially if you look at the Irish redress scheme, and I'm talking about Southern Ireland here, where it was the same perpetrators who were moving from Ireland over to Scotland, abusing children in Scotland, moving back over to Ireland, abusing children in Ireland. And yet within the Irish redress scheme, now I know we're talking slightly different here, we're talking about the Irish redress scheme went through what would be equivalent to our civil courts. But the payments there started at 50,000 at the lowest level and 300,000 euros at the highest level. Now, how can the same abuser who's allowed to travel between Ireland and Scotland come over here and abuse the children in Scotland the same way that they did in Ireland, and the children in Scotland be expected to accept payments between 10,000 and 80,000? Now, I say that with absolute respect. I know that because the redress scheme may well be seen as slightly a less traumatic experience for the survivor, I can understand a percentage of difference, but not at the level that it's at. I don't think, I'll be totally honest with you, me personally, I think the highest level of 80,000 is an insult to survivors who have experienced abuse, and I'm talking about people who were put into care as babies, infants, preschool, right up until the age of 15 and 16, their whole childhoods being denied, and within that period of their childhood, being abused at every level. How can 80,000 equate to that? And I mean, I know it's horrible to put a financial sum against abuse, but it needs to be a financial sum that's seen as justified. It's seen as some kind of justice for the survivors. It's seen as an absolute acknowledgement to the survivor of recognition of the level of abuse that you've been through. I mean, abuse never ever leaves you. It's like a shadow. It's like a human shadow. Sometimes it's behind you, and you can get on and you can put it behind you and forget it's there for a little while. But then it moves to the side, and you're conscious at your eye level that it's there, and it starts to have an impact. But there's other times when that shadow's right in front of you, and no matter how strong a survivor you are, you cannot ignore it. You have to deal with it. You have to do whatever you have to do in order to be able to cope with it. You have to put whatever support you can put in place to be able to cope with it. So it's a lifelong issue that survivors have to live with. It doesn't just go away, and it won't just go away once survivors receive redress either. It's always going to be an issue. The damage has been done. The impact on the survivor life is there. Sometimes we can deal with it a little bit better than other times, but the reality is it's there. It's with us forever. It's like our arm or our leg or whatever. It doesn't, because we've been abused as children, that doesn't have to define who we are as adults. But it certainly is still with us as adults.
Thank you. I think Mr. Collins wants to come in, and Mr. Aitken.
Thank you. Very briefly on the first point, I am concerned about the broad banding that is there, because if there is, for example, a level of abuse that will justify a payment of 10,000 that then goes up to 20, 40, 80, it follows that there will be a line in each of those bandings. And someone who falls on one side of that line will be looking at a scenario where perhaps for 1 week less in care, 1 month less in care, one thing less happening, that level of grading, they are assessed as abuse, which is half of the value of the next level up. There's two things about that. It doesn't seem particularly fair. It runs the risk of survivors being seen as a commodity again, which has been in the past. And I'm concerned about that, and I think there needs to be more individual assessment. The second point is the upper limit, I would say to you, must not apply to pre-64 survivors. And the reason for that is myself and Helen, and I'm aware that both Harry and David and others some who are no longer with us, were in a meeting prior to time bar legislation being announced when Angela Constance told us in that room that there would be a solution provided to pre-64 survivors that would put them on an equal pegging with those who have a right to claim in the civil courts. That was taken forward by Mr. Swinney and others since. That has always been where we've been looking at from the point of view of redress. Pre-64 survivors have no other means of redress. To cap their award at the top level that is provided here is not to treat them equally as the pre-64 survivors who have the right to access to the courts. If that promise, which meant a lot to those who were in that meeting all those years ago, if that promise is to be delivered, then it requires pre-64 survivors should be assessed as they would have been had they been making a claim through the courts.
So I got Mr. Aitken and then Mr. Whelan.
Yes, taking a look at the banding, there's a feeling around the community that the majority of survivors will be placed in the band of £10,000. But if you take a person who's been in care for a year, that would be £27.40 per day. 5 years, it would be £5.50 per day. 10 years, £2.70, and 15 years in care would be £1.80. Follow that up with the method that the Scottish Government have used. The proposed range of the awards does not acknowledge the fullest extent of living for a prolonged period in an abusive, neglectful, and destructive environment. And that is something that is missing from the bill. There is another question I think I'd like to raise. Why is it cut short to 5 years? Other jurisdictions have used a longer time span for applicants to apply. The key factor then is to consider, for the Scottish Government, the continued funding and duration of the Scottish Government Redress Scheme allows that no victim or survivor is disadvantaged for whatever reason they may delay in applying. I'm very conscious that I was about to raise again the pre-64 issue, but Mr. Collins has done it well. And I think that'll be enough for today for me.
Thank you, Mr. Whelan.
Yeah, can I just say we support what Simon and Helen are saying in terms of the pre-64 issue, because we were at that meeting as well. In terms of the levels, I think we've said in a written submission that we would like to see the migrant issue addressed, and we've suggested how that can be it feels strange to us that in one part of the UK you have legislation that awards 100,000 in terms of a redress scheme for a citizen in the UK, but in another part of the UK, but here, whatever. But we also believe that the upper limit does not address the most complex, serious abuse, including the rape of a child over a number of years in an institution. And that is just as an example. We don't believe that 80,000 is sufficient to address that harm and the trauma that created. What we would like to see is the panel be giving explicit discretion in making decisions. But for us, it seems like the government have put something together and the discretion has been taken away from the panel. So we would really like to see that the panel within the bill can have the discretion to make the awards that fit the individual. In terms of the 40 to 80, we still don't understand the gap there. We don't understand it. And yeah, so I think I've covered the points I want to cover.
Thank you very much. I was wondering, Mr. Johnson, are you finished?
Well, I could go on, but I recognise the time pressure.
Okay. Ms. Mackay, did you want to come in on this issue? Have your questions been covered?
Well, no, they haven't. But I genuinely don't think we've really got time to cover them at this stage, Claire. I mean, you know.
I know a number of members haven't contributed today, and that's because we've got areas that we haven't been able to get to in the time. I wonder if Ms. Wishart, if you think the care settings could be covered very quickly, just before we finish up, if you want to come in.
Yeah, thank you, convener. Yeah, I just wanted to get views on the care settings not covered by the scheme, and it was actually the boarding schools issue. And one of the submissions that we had gave an instance of a boarding school of where, say, 10 children were abused and 3 were state-sponsored. So 3 would receive redress and 7 would not. So I just wanted the panel's views on that, because, as has been often said, abuse is abuse. And I wondered what the panel's views were.
If we could keep to succinct answers to that. Ms Henderson, I'm conscious you haven't been in for a while. Do you want to respond to that question? Yes, I'm bringing Ms Henderson.
Yes, just briefly, what Future Pathways would recognise is that it can be really problematic if survivors who experience the same abuse in the same setting are treated differently, and we would just highlight the potential for really negative impact regarding that. And we would also say that we're very much aware of the impact and hurt of abuse in all residential settings. And in such circumstances, that day-to-day duty of care was in the hands of the institution. And also that there would be a real vulnerability associated from those living apart from parents or caregivers for an extended period of time, and the trust associated with that. And we would just observe that institutions should not be absolved of their responsibilities to children in their care. Thank you.
Thank you. I'm looking, does anyone else want to come in on those points? Ms Holland?
Yeah, thank you. I think we've always made it perfectly clear this is a state responsible redress scheme. And the children we're talking about, and the children that the petition was put into Parliament in relation to, were children who were under the care of the state. Now, my heart goes out to any survivor, regardless of where they've been abused. But the reality is, this is about children who were directly under the care of the state, where the state had care responsibility. The example that you gave there in relation to 3 may have been sponsored from a care-run institution and therefore we're going back to the care-run institution, I absolutely take that on board. The other 7 survivors, and I say this with absolute respect and empathy and compassion, the reality is their parents could have turned up at that boarding school at any time and said, I'm moving, let's say, Helen, from this boarding school and I'm taking her to another boarding school because she's not happy. Our parents couldn't do that. Our parents were denied that right. Their parental rights were taken from them when we were under the care of the state. And that is a massive difference in relation to what this redress scheme is about. Otherwise, it becomes a situation where every kind of abuse, no matter where it's happened, the state are going to pay redress for. It's not the way that it works. I mean, it makes no sense to widen it to the point where it becomes non-existent and it's not achievable. And that to me is the major point more than anything. The reality is, as I say, our parents were paying the state contributions for our care, and yet there were times when my dad turned up to see me and the door was slammed in his face and he wasn't even allowed to come in. He couldn't phone up and say, I'm going to move Helen from that children's home because she's not happy, and I'm going to place her in another children's home with a better reputation. That just wasn't available to it. It wasn't an option. And that to me is the major difference about the care settings. And I think I absolutely say that with all due respect to anybody who's been abused. In my opinion, if people have been abused in a care setting where there's a board of trustees or people who are responsible, then they're the people that they should be suing. They're the people where they should be targeting all their energy to make sure that they get justice. And I would absolutely wholeheartedly advise them to do that. The reason we're looking at in-care redress is because for years, up until 20 years ago, nobody was looking at the abuse of children under the care of the state at all. Even when we were first trying to bring this into the public domain and into the Scottish Parliament, there were many, many groups out there who didn't want to hear about it at all and didn't want to offer any any kind of support. The reality is we've had to fight long and hard for the state to take on board this responsibility and acknowledge the fact that they were our parents. I hate saying that, but it's true. They became the parental responsibility for every child in the care of the care system. And it's the care system that we're looking at within this redress. It's those children who were supposed to be having the parental care of the state not being properly looked after and being abused instead of being looked after and being neglected instead of being cared for, never having a cuddle, never knowing what love was. And not all of those children came from abusive early age before going into care. Some children entered care from a home where there was no abuse whatsoever. It may just have been a parent that had died or a marriage breakdown or whatever in today's society. And those children were automatically taken into the care of the state. We were also financial commodities within that role as well. The care providers were being provided finance, supposedly, to provide a level of care under the legislation for the state. The 1948 Children's Act talks about all the different things that should be in place. I went into care long after 1948, but yet suffered over a decade of abuse. So it's entirely different. It's not a case of where there were choices. There were no choices for children taken under the care of the state. There were no choices for the parents to be able to come and do something in relation to the children under the care of the state. So it's entirely different. And I'm sorry to say that. I don't say that with any disrespect to anybody who's been abused in any other setting. Absolutely not.
Thank you, Helen. Sorry to cut you off. We are right up against it. Mr. Whelan, if you could come in, I'll give you the final say very, very briefly.
We believe where the state had a duty of care, a duty of responsibility, a duty of inspection, then that they have those duties. And if those duties failed, then they failed those children, whatever setting that was. In terms of what Helen has said, what we would say to the government is if you can't address these issues in this scheme, then we say you should do the same thing as Ireland did with the Magdalen Laundries. They had another scheme which came after the main redress scheme. So don't ignore the issue, address the issue, because ultimately you had responsibility for it.
Okay, thank you very much, Mr. Whelan. Apologies to Ms. Bishop. I hope that's covered her question. I think there's a general consensus from the chat, which we don't normally have in committee, but we've got in a virtual world, that we haven't covered all the areas that we would have wanted to today. So we need to go away as a committee and think about how best we can address that, whether it's another committee meeting if possible, or to do so by letter. And apologies to any of my colleagues who wanted to come in, they weren't able to today. We're now going into private session, but just a huge thank you to everyone who have given their time again. It's not the first time you've helped the committee in our deliberations, and we really do appreciate that. So I'm now going to close the meeting, and if members could move to Microsoft Teams briefly, we can have a discussion on the evidence today. Thank you very much.